Welcome to Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now you can learn about the law and how to protect yourself against the loss of your liberty or property. Learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is Attorney Kenneth J. Landau with the Mineola Law Firm of Shane, Dox, Denisi, and Corker. He's a member of the Committee on Professional Ethics of the Bar Association of Nassau County and counsel to the Nassau Academy of Law. And now, here is your host for Law You Should Know, Attorney Kenneth J. Landau.
Hi, this is Ken Landau, and welcome to Law You Should Know. Today we're talking about the new Alternate Dispute Resolution, also known as ADR for short, of the Bar Association of Nassau County. And I'd like to welcome Elizabeth Donlon, who is one of the founders of the program, and she has offices in Floral Park and concentrates in the area of estates and trusts, although she is moving into acting as a mediator or arbitrator full-time, and also Marilyn Genoa, and she's involved in commercial matters and small business matters and real estate litigation. Welcome to Law You Should Know.
Thank you, Ken.
Thank you, Ken.
This is a big step for the Bar Association, and alternate dispute resolution, including mediation and arbitration, become much more popular in recent years for resolving all types of disputes, large and small, in all areas of the law. So I'd like you to explain to our listeners how this new program at the Nassau County Bar Association can help them in resolving legal matters. And Betty, first of all, tell us about ADR and how the Nassau County Bar Association is getting involved in offering that service to its lawyer members and the general public.
Well, essentially, what has happened at the Bar Association recently is that through the major efforts of Marilyn Genoa and others, an existing panel or panels for arbitrators and mediators has become revitalized. We call them mediation and arbitration tribunals under the general heading of ADR. And what these tribunals are is a way for litigators or the public who are contemplating litigation or who are seeking an alternative way of resolving a dispute can come to the Bar Association and essentially pick a mediator in the case of a mediation or pick an arbitrator from a list of qualified individuals, and for a much lower cost than embarking on litigation can resolve their disputes.
And it's also going to take less time.
Absolutely.
And for anyone who's not aware, can you just briefly tell us the difference between mediation and arbitration?
Yes. In an arbitration, the parties, usually arbitration comes about because there's a contract between parties that calls for arbitration. That doesn't mean that the parties can't simply elect arbitration, but generally it's a contractual obligation on the part of the parties if a dispute arises. In an arbitration, the parties, if they go through the Nassau County Tribunal, pay an administrative fee to the Bar Association. The fee is $500. They receive a list of available arbitrators, perhaps in their subject area, if there are enough arbitrators who concentrate in a subject area, and they choose an arbitrator. Then they pay $300 an hour to the arbitrator. And let me just point out, that's $300 an hour in total, and generally the parties will split the cost. And they'll generally split the cost of the administrative fee, too.
So the fee is a total fee, not per party?
Yes.
Okay, so that may be one cost advantage of the Bar Association Nassau County program over other providers, because the other providers usually have various fees that each party pays.
That's correct.
And just to make it real simple, the arbitrator is acting sort of like a judge and deciding the case.
And it's binding.
Mm-hmm. And the mediator is
is nothing like an arbitrator. An arbitrator, as you point out, is like a judge. The decision of the arbitrator is binding. In a sense, although I'm not all that much familiar with arbitration, and Marilyn can certainly elaborate, but in a sense, what an arbitrator does is conduct a mini trial. if that's correct.
It is to a degree, but one of the benefits of arbitration is you get to set more of the framework, the guidelines. We're not as strict about the guidelines at the Nassau County Bar Association, so discovery is more fluid. It depends on what the parties determine that they're going to arrange. The arbitrators will set a meeting in advance. You also have something that you may or may not decide is something you find beneficial, but it's non-appealable, so you have a finality to the decision at the end of it. And it's not you go into court and whatever hopper they pull the judge out of and you're assigned one, you get to determine which arbitrator you and your attorneys choose.
And you can sort of pick the ground rules, the
Correct.
issues, and the scheduling too. You have control over all these things you would not have in court.
Absolutely.
Control is a very important aspect.
And you might also be able to set a minimum and a ceiling to be protected in case there's a finding either side doesn't like.
The rule, that's one of the major benefits of alternative dispute resolution, is that the parties are far more in control than they are when you're just in litigation in the court.
And of the cost and the time frame as well. And that's important
Very
to control.
critical.
Now, the mediation, the mediator is going between the parties, it could be two or more than two, and trying to accomplish a meeting of the minds, kind of like a labor dispute.
Yes and no.
Okay.
Okay. The mediator, just like an arbitrator, is totally neutral. The mediator's job is to facilitate a resolution of the conflict between the parties. The mediator, as a general rule, does not try to make a suggestion as to how the parties may settle a dispute. The mediator simply facilitates the parties and their lawyers coming to a resolution.
Well, I mean, from my experience in being involved in mediations, that means it helps if the person can float different ideas that the parties can then agree on in order to build a resolution of the dispute.
But
that can happen.
And it does depend also on the mediation, and there are different things. So the parties may say that they want to have a mediator suggestion or they want something, but in going back and forth, it's something that the mediator has to get a feeling of what the parties want, and you go back and forth and you determine it. And a mediator will potentially feel out what may be a suggestion. And even though you're facilitating the parties making the decision, in mediation, it often comes out that a mediator may say, what if I were able, what if they were to do this? Would you be willing to do that?
And it might be a couple different issues,
right,
a package, right.
But usually those are done in confidential caucuses so that the other party is not aware of any of those suggestions.
Absolutely. It's not binding. The mediator is like a facilitator, sort of like a go-between, trying to bring the parties closer together. It's a special skill.
It absolutely
in understanding where each party is coming from, understanding some of the legal issues involved, and they try their best to resolve it, or at least resolve some of the issues.
And even if a mediation works to resolve one out of several issues, the parties are ahead of the game.
And also the beauty of it is the parties have a resolution that presumably they can live with because they're both, or even more than everyone, they're okaying it. So that chances are they'll live within it and they can live. It's a sort of a win-win situation.
It's absolutely a win-win situation.
Elizabeth's
and mediation,
favorite phrase.
this is my favorite phrase, but everyone is a winner with mediation. Okay. And it's an empowering process.
And Marilyn, is there anything else you wanted to add about the benefits of ADR over the traditional ways of litigation, which is sort of a win-lose?
I think we lightly touched on all of it, but you just hit what litigation is. In litigation, and as a commercial litigator, I see it, my clients will come to me and they will say, although I have to tell you in our practice, we wind up mediating or negotiating more than litigating. Litigation is an extraordinarily costly issue. Whether it's not just costly in dollars, it's costly in emotion, it's costly in time away from the office for our commercial clients. It's something where you may go in there saying, I have a phenomenal case. It's a matter of principle. I want to do this. But at the end of the day, I don't know anybody who's really happy because the time it's taken, the issues that come out, the things that they see coming out on the stand, plus you think you have a great case, you think you have a wonderful attorney. It's up to the person who's sitting on that bench wearing the robe and how they feel about that issue that day, or the jury of your peers if it's a jury matter. And even if you should successfully win, there are appeals. So you can be there for years and years and years, and you win your appeal, you go to another level of appeal. Finality is something that takes forever, and I will tell you that almost no cases actually, at least in the areas that I practice in, which are commercial real estate, commercial litigation, there are almost no cases that actually go to trial. At the end of all the time and money and expense that you've spent, you wind up coming to some type of a settlement, and that's a settlement that's usually pushed upon you by the judge, and we've had clients who've had that happen to. So you're up to
it may not be so voluntary. The judge may say, "This is how I see it. Sign it," or risk a worse result if we go to trial.
Absolutely.
So litigation is uncertain. Litigation could have a win-lose scenario, or perhaps lose-lose scenario, because everyone may be unhappy.
Correct.
Betty, anything you'd like to add on that?
Not really. I think we've covered all the high points of both arbitration and mediation.
Okay, and you mentioned about choosing the mediator or arbitrator. Is there anything else that you'd like to say about that?
Well, in connection with the Nassau County Bar Association ADR panels, or tribunals as we call them, again, if there are attorneys involved or if there are clients involved without attorneys, they'll be provided with a list of 5 names along with one-page resumes of potential choices to be either arbitrators or mediators. So they choose who that person is and have a background as to who they're selecting.
And so parties, if they're not represented by attorneys, they can approach the Bar Association and make use of this dispute resolution mechanism. If parties have attorneys, they can approach the Bar Association through their attorneys and utilize it as well?
Yes.
One thing that I think is important, and I don't believe we've mentioned it, all of the arbitrators and mediators who are on the tribunals at the Nassau County Bar Association had to have been screened by the Judiciary Committee of the Nassau County Bar Association, which is something that I don't believe any of the other mediation or arbitration panels anywhere have had.
And these are all lawyers?
They're lawyers. They're the Judiciary Committee at the Bar Association, who are the ones who screen the candidates for different judicial positions. So we have our arbitrators and mediators also submit their backgrounds. There's an application that has to be filled out, and they do have to go for screening as well.
And the parties can pick the mediator or arbitrator they want from among the
But
list.
it has to be, and it's important to also realize that they have to jointly pick it. So
they both have to agree on it, yes.
Right. If they don't
Right.
like the first list of 5, they can't come up with a name that they agree on. Well, it may not work that way, because if the first list of 5 is passed along and they can't agree on anybody from that list, they get a second list of 5 and they can't agree it, then our administrator will pick from the third on their own.
If they know who's on your panel, can they just pick the person they want?
I don't see why not.
Yeah, most organizations, if you have someone you really trust, you can just ask for that person.
We haven't had that happen yet, but we're new, and I guess if it happens, we'd probably allow that.
Mm-hmm. Let me just point out, in terms of qualifications also, our panelists on the arbitration panel are all attorneys admitted for at least 10 years and have had arbitration experience and are members of the Nassau County Bar Association.
Okay.
And we do have a lot of retired judges on our panel.
We're going to take a short break now. In a moment, we'll return to our discussion of the Nassau County Bar Association ADR program, and our guests,
Once again, we continue with
Betty
Law You Should
Donlon
Know.
and Marilyn Genoa. You're listening to Law You Should Know here on 90.3 WHPC, the voice of Nassau Community College in Garden City, Long Island, New York. We'll be back in a moment.
Hi, we want to tell you about a program with real appeal. There is a high-quality, low-cost paralegal studies program right here at Nassau Community College.
It can be your major while earning your associate's degree.
Or taken as a certificate program if you already have a 2- or 4-year college degree.
It can be the start of your legal career or a great second career.
It is also a great credential in the business world.
Many of our paralegal graduates go on to 4-year colleges and even law school.
You can complete the certificate program in several months. Paralegals work in private law firms, government, and corporations on Long Island and New York City.
You can start in the summer, fall, and winter, attend full or part-time, days, nights, or weekends.
Our tuition is low and the program is approved by the American Bar Association.
For more information, contact the Paralegal Program at 516-572-7774 or email us at paralegal@ncc.edu.
Once again, we continue with Law You Should Know. From the Mineola Law Firm of Shane, Dox, Denise, Corker, and Sauer, here is Attorney Kenneth J. Landau.
Welcome back to Law You Should Know. We're talking about the new Nassau County Bar Association ADR, which means Alternate Dispute Resolution Program, which makes mediation or arbitration available to the general public to resolve individual or business or any type of disputes. Our guests from the Bar Association discussing the program are Marilyn Genoa. She's also an attorney in private practice concentrating in commercial matters, real estate, and issues involving small businesses. And Betty Donlon, who's an attorney in private practice, primarily involved with trust and estate matters, but also becoming more involved with mediation. And Betty, you would want to talk about the qualifications of the mediators who are on the Nassau County Bar Association panel.
Yes, the mediators who are on the panel, along with the arbitrators, or as Marilyn pointed out, are all screened by the Judiciary Committee. They have to be members of the New York Bar for at least 10 years, members of the Nassau County Bar Association, and must have had at least 40 hours of OCA, that's the Office of Court Administration, approved mediation training.
Okay. And mediation is becoming a very big field. And perhaps before we talk about some examples of successful mediations, what are some of the types of the varieties of areas of law where there are disputes conducive to mediation arbitration through the Bar Association panel? Marilyn, go.
We believe that everything can be resolved through mediation.
What are some areas where it's very common?
Commercial litigation is an area that's becoming more common. The courts are actually sending some of the commercial disputes that are in the court to mandatory mediation. That they only have to do a few hours, because once you're in court, we can't really send them out where you have to pay to do it. But commercial matters are very often mediated. Matrimonial matters are now becoming more of a mediation area. There's conciliation divorces where that's handled very differently. You have attorneys an attorney will act on behalf of their client. Another one, they try to resolve that through a mediation process. If it doesn't work out, they have to go back to the drawing board and everything remains confidential. But they're dealing in that area now. Those are the areas primarily that I don't really deal in the matrimonial, but I've been dealing with the commercial matters for a very long time.
But also, Betty, you're involved in trust and estates. Is it conducive to that if there's a fight between a trust or a fight over an estate?
Oh, absolutely, Ken. As a matter of fact, there's a major movement afoot through the state bar, and I hope to introduce it also through the county bar, for resolving estate-related disputes that normally take place in the surrogates court through mediation.
And this also might work for employment discrimination. It might work for disputes between neighbors. The idea is to have a resolution that both parties can buy into in a cost-effective, timely manner.
Yes.
When you're dealing with neighbors especially, they're going to be living next to each other for years. If you have something where someone's been giving a judgment by a court and the other one hasn't, and you still have that ongoing hostility, it's not all that wonderful. If you can find a resolution that both parties come up with and can live with, they're going to be living.
And the mediator, their job is to help them come up with some kind of resolution. Help facilitate it.
Mm-hmm.
And just tell us how someone can find out, an attorney out there or a resident of Nassau County can find out more about this panel.
Well, attorneys who are members of the Nassau County Bar Association can join the ADR committee and learn more about ADR.
But give us the contact information for the Bar Association.
Okay, well, I believe you can call the Bar Association at 516-747-4070. Also, there's a website, nassaubar.org, and there's a link to ADR, Alternative Dispute Resolution, and find out the rules for our panels, the applications to be mediators and arbitrators. And we hope to be putting more information on the website.
We also have the ability, if there are groups out there who are interested and want to learn more about it, the Nassau County Bar Association has a speakers bureau, and we have speakers who are willing to come out and discuss it free of charge. If they've reached out to the Bar Association and have an area or a topic of interest that they already have requested a speaker, we have members of the Alternative Dispute Resolution Committee who have expressed a willingness to go along with that speaker and explain how an area, if they've asked for a speaker in something to do with selling property, commercial real estate or regular real estate or estates and trusts, and they have a speaker coming to discuss that area of law, to have someone come in to discuss mediation as well.
Okay, and perhaps you can give us examples of some disputes that were resolved successfully through ADR.
Okay, we had, we're going to just discuss some samples of different types of resolutions that may sound a little interesting to some of your listeners, so that they would know that it isn't something where I'm suing you for $50,000. We're going to mediate. I get $40,000. You don't have to pay me the other $10,000. Mm-hmm. Things are not that simple in mediation. So you had discussed an employment matter, and someone who had been fired in an age discrimination suit. The employer absolutely denied that. They went back and forth, and sometimes you can do things in mediation that a judge absolutely has no ability to do. In this case, they discussed it. They realized that his recognition and the respect, the employee who had been fired, he wanted to be recognized. And they came up with something that was unique just to this person. They called it a retiree's ID card, which they invented just for him. That allowed him to come back onto the premises. He could come back. He could schmooze with his old cronies. And it was a perk that showed to him that the company respected him, and it gave him the ability to have social support from the old workers that he had. So that alone relieved some of the tension, and he actually withdrew the lawsuit. And he was happy because he got some of the respect. And in talking through that, through the mediation, because we say that people need to vent, they need to explain, you need to listen, and everyone is given an opportunity in mediation to speak. So that was one of the ways that something was resolved. Another one had to do with someone who was discharged for disability claims. Again, the college absolutely denied that they had fired this person because of their disability. And in part of that resolution, they came up with something where they would do something in the future where they would do a run in honor of her disability. And that gave the person a feeling of worth. So there are all kinds of things that can come out. And
they really have remedies and resources that a court would not have. The court might be able to grant an injunction, to award money. Someone might be very unhappy. It might be overkill. But a mediator, perhaps an arbitrator, can tailor the resolution to keep everyone placated and to keep that to make that dispute go away, now and in the future.
Absolutely,
they can use. We can come up with a creative solution that a court can't come up with.
And also, the parties will have a chance to vent, make their feelings known. The mediator more likely will listen to it, perhaps can take something out of that in fashioning the resolution.
Correct.
While a court is not really interested in venting.
No, although some of the better jurists do what they call settlement conferences, and they do that, but they still have to only give a decision which is in accordance with the laws that they have. I'm a village justice as well, and I have to. I can't do much, but I do try to make people understand.
Your hands are kind of tied on what you can.
They're tied, and I will suggest that maybe people want to walk out of the room and try and settle.
Mediation in particular gives the litigants an opportunity to speak with one another, whereas with litigation, once the litigation commences, the parties don't talk to one another.
If that's productive, sometimes it may not be, productive for the people to speak to each other, at least in the initial phase of it. That might just escalate the dispute.
In litigation?
No, in mediation.
I'm saying the parties may not be ready to speak to each other initially.
But a good mediator, that's why you have a pre-mediation conference. And you always reach out and ask the attorneys, can I have these people in the room?
And the best thing is it's not binding, so that people aren't really giving up. The mediation may be binding?
No, it's not that it's binding, but what you want from a mediation is you want the people at the end of the mediation to come up with a resolution where you're sitting down and having an agreement that they sign off on.
And chances are that's going to happen, but people shouldn't be afraid to take the plunge because they don't give up anything. That's what I'm trying to say.
They're absolutely not giving up anything.
And you also lose a lot of weight. In court, you're waiting, or your attorney's waiting, and you're paying money, and you're losing time, and it's not accomplishing much. You're just waiting.
That's correct.
So at least your time and money are being used productively.
That's the goal.
We just have a few minutes left in the program. I just want to give each of you another minute and perhaps, Betty, you can remind us of the contact information and just tips on making the most of the process and making it work for a person or their counsel.
Okay, well, the contact information at the Bar Association, I hope I have this number right.
It's correct. Go ahead.
516-747-4070. The Nassau County Bar Association website is nassaubar.org. Click on Alternative Dispute Resolution, and you'll be headed toward the right direction for that information.
And just briefly, why the ADR works.
It gives the parties and their counsel an opportunity to resolve a dispute without the extraordinary costs and delay and aggravation and turmoil that litigation generally involves.
Okay, and Marilyn?
I don't think I can add much more to that other than the attorneys should also recognize that for them, it's something where it enables them to end a dispute much more quickly on behalf of their clients, and it usually lends itself to a much more happy client and one that's usually very satisfied with their attorney.
And a happier resolution, too.
Mm-hmm.
And I just want to mention, as you mentioned in the beginning of the show, people can approach the Bar Association on day one before there's a lawsuit.
Mm-hmm.
People can approach the Bar Association during the dispute. And even at the tail end, when it's getting ready for trial, it's still not too late to take advantage of mediation or arbitration.
Absolutely.
And with arbitration, people can agree to different parameters, perhaps even making it non-binding, and also to put a high and low in place so both parties are protected from a runaway result.
I'm not sure that our rules say that it would be not binding, but I'm sure that they can if they choose to do that.
It would be
but
unusual.
The point of it is to come up with a binding resolution, but they certainly can set the parameters that they want, and it definitely cuts all of the costs.
I wish we had some more time, but I would thank both of you for telling us about the ADR panel at the Bar Association Nassau County. I'd like to thank everyone for listening, and please join us next week at this same time for another program on law you should know here on 90.3 WHPC, the voice of Nassau Community College in Garden City, Long Island, and also on the internet at ncc.edu/WHPC. And many programs are available at no charge as a free podcast from itunes.ncc.edu.